Okay. Yesterday we have seen the two categories of reservations. The reservations excluding the legal effect of certain provisions of the treaty, and reservations modifying the legal effect of certain provisions of the treaty in relation to the state issuing the reservation, and conditional interpretative declarations are a kind of a reservation which modifies the legal effect of certain provisions of the treaty in their application to the issuing state. Now, well, let us see just an example of, we will see in a moment an example of the first kind of reservation, an example of a conditional interpretative declaration in the intention of the, at least in the intention of the issuing state, is the reservation, for example, of the United Kingdom to the additional protocol to the Geneva Conventions of 1949, the additional protocol of 1977, additional protocol 1 on the protection of victims of international armed conflicts. The United Kingdom government here reserves the right to extend, continues to be the understanding of the United Kingdom that the rules introduced by the protocol apply exclusively to conventional weapons. Just to specify, the protocol limits the use of weapons, in particular on the basis of certain fundamental principles. For example, indiscriminate weapons are prohibited. Weapons that cannot be directed against, if directed against a specific objective, but then produce effects which go much beyond the specific target, and which can indiscriminately affect both military objectives and civilians and civilian objects. These are indiscriminate weapons. Other weapons which are prohibited are the weapons which produce on the enemy combatants unnecessary suffering. So suffering which is not necessary for the pursuing of the military advantage by the attacking state, by the state using it. Now, all NATO states, not only the United Kingdom, also Italy and the other NATO states, have issued a declaration in ratifying the protocol, according to which their understanding is that the protocol applies exclusively to conventional weapons, so not to nuclear weapons. This is stated nowhere in the protocol. There is no rule in the protocol excluding nuclear weapons. And the International Court of Justice, in its advisory opinion on the use of nuclear weapons, on the legality of the use of nuclear weapons of 1996, we will come back to this advisory opinion. We will probably mention it later on. Stated clearly that the rules of the protocol apply to nuclear weapons. So this is, but the United Kingdom is issuing again this declaration at the beginning of the year 2000. So after the advisory opinion of the court, in fact, it states it continues to be the understanding of the United Kingdom that the rule introduced by the protocol apply exclusively to conventional weapons without prejudice to any other rules, so customary international law applicable to other types of weapons. In particular, the rules introduced do not have any effect on and do not regulate or prohibit nuclear weapons. So it contradicts the International Court of Justice. The International Court of Justice did not say that it was an ambiguous opinion of the court. It did not say that prohibited the use of nuclear weapons in any case, but it said that nuclear weapons were regulated. Those rules. So this is a reservation because the United Kingdom purports to exclude the application of certain provisions of a treaty, the additional Protocol 1 to the conventions, to itself. Now, let us see what are the effects of reservations. So what happens when a state is issuing a reservation of any kind, either including or conditional interpretive declaration? The traditional view, at least in Europe, was the full conformity to the integrity principle of the treaty. So the integrity of a treaty had to be safeguarded. The effect was that a reservation, to be possible, needed to be accepted by all other states parties to the if it were not accepted by some of the other states parties to the treaty, or by all of them, the reserving state could not be party to the treaty. This is a logical consequence. Logical consequence of the principle pacta sunt servanda. Treaties are to be respected. The state cannot participate in the treaty and at the same time stating that it will not comply with one provision of the treaty, or it will comply only with an interpretation which is not shared by all the other states. Because this is a contradiction of the participation in a treaty. So, if you have the acceptance of a reservation by all other states parties to the treaty, the integrity of the treaty is not prejudiced. Why? Why the agreement of all other states does not prejudice the integrity of the treaty? Yes, thank you. Your colleague says treaties are based on consent, and so the other states give their consent. You are okay, because we may say that if there is the acceptance of all the other states parties to the treaty will be modified for everybody by that reservation in relation to the state issuing the reservation. So there is an agreement. It is always full respect of the principle pacta sunt servanda. However, the traditional rule, this traditional interpretation, was not allowing, was not flexible, and could prevent the ratification by a high number of states of important multilateral conventions. The issue came before the International Court of Justice in 1951. The issue concerned the Genocide Convention of 1948. Because the text of the Genocide Convention, the convention prohibiting and punishing for the prevention and punishment of the crime of genocide, contained an article, Article 9, according to which disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of the state for genocide, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute. It is on the basis of this provision that the International Court of Justice has recently pronounced on genocide in various cases. Bosnia versus Serbia, and also on the case of there are also other cases. There is a case which is being considered now, and one has to see what will be the issue. Anyway, the court has pronounced on the basis of this provision various times in recent years. Now, the point was that the Soviet Union, while ratifying the Convention Against Genocide, put a reservation on Article 9, because the Soviet Union did not want to recognize the jurisdiction of the International Court of Justice on disputes relating to the Genocide Convention. Therefore, the Secretary General of the United Nations didn't know in the registration of as it was the depository of the ratifications of states for the Genocide Convention, he didn't know whether he could accept or not the ratification of the Soviet Union, if the Soviet Union could be considered a party to the convention or not. Therefore, a question was asked to the International Court of Justice. Whether a state could be considered party to a convention in case some states accepted its reservation and other states objected to its reservation, because there had been objections to the reservation of the Soviet Union to the genocide. The answer in the advisory opinion given by the court in 1951, under the request of the General Assembly, the International Court of Justice introduced the first elements of flexibility in the doctrine relating to reservations. It stated that, of course, in the absence of a provision in the convention, because the question is often regulated by the treaty itself. So it is obvious that if the text of the treaty provides that certain reservations are admissible, other reservations are prohibited, what matters is the text of the convention. But in case the convention does not regulate reservations, which is the case of the Genocide Convention, no rules on reservations, what how does one have to behave? The court answered that a state which has made and maintained a reservation, which has been objected to by some parties to the convention, but not by other parties to the convention, can be regarded as being a party to the convention if the reservation is compatible with the object and purpose of the convention. Otherwise, the state cannot be regarded as a party. So the criterion, in case the convention does not provide on reservation, the criterion to understand whether a reservation is permissible or not is compatibility with the object and purpose of the convention. We have already mentioned this in the interpretation, this question of the object and purpose of the convention. So it is clear that the reservation can be accepted if it does not prejudice the reaching of the object and purpose of that convention. Now, what do you think about the reservation of the Soviet Union? Was it compatible with the object and purpose of the convention? Not if you read the textbook. For those who have read the textbook. There is no incompatibility on a reservation on a jurisdiction clause, because, I mean, it is obvious that if you do not permit the International Court of Justice to decide on disputes relating to genocide, this may hamper the reaching of the object and purpose of the convention, because it might be easier for a state to avoid being identified in the case whether it violates the convention. However, it's not the jurisdiction clause per se that guarantees the reaching of the object and purpose of the convention, or its absence, which prevents the convention from reaching its object and purpose. Convention, the genocide can be prevented and punished even if the International Court of Justice is not competent to deal with disputes. Now, however, who decides on the compatibility of a reservation with the object and purpose of the convention? The problem is that if the question is brought before a competent body, an international court, the international court may decide. But if that is not the case, it is the parties which will have to decide. As always in international law, it is always states which have to decide on disputes, unless there is, in the specific circumstance, a competent body. Therefore, the court concluded that if a party to the convention objects to a reservation, which it considers to be incompatible with the object and purpose of the convention, according to the court, the objection had to be based on considering the reservation incompatible with the object and purpose of the convention. So that had to be the criterion for objecting or accepting a reservation. So if a party to the convention objects to a reservation which it considers to be incompatible, it can consider that the reserving state is not a party to the convention. If a party accepts the reservation as being compatible with the object and purpose, it's clear that the state cannot accept the reservation if it deems that it is incompatible with the object and purpose of the convention. So the accepting state can consider the reserving state a party to the convention. This is, as you can understand, a breakdown of the principle of the integrity of a treaty, because it will be possible for a state to ratify a treaty with a reservation and to be considered by some state parties to that treaty, some other state parties to that treaty, as a party by some other state parties to that treaty. No. Because the first considered reservation compatible with the object and purpose.
I'm sorry. We can hear really badly from home.
Sorry, I was a bit far away from the microphone. Can you hear me now?
Yes, yes.
Okay. Did you hear my previous words or not?
No.
Okay. So I was saying that if that the principle adopted by the International Court of Justice introduce an element which breaks the integrity of a convention. Obviously, the court was talking in relation to a convention, a lawmaking, as we could say, lawmaking convention as the Convention Against Genocide, big multilateral lawmaking convention. Because the integrity is broken, because a state can be considered, a state which has ratified the convention with a reservation can be considered as a party to the convention by some other states parties which accept the reservation, considering it compatible with the object and purpose of the convention. And it can be considered not a party to the convention by some other states parties to the same convention, because they consider the reservation as incompatible with the object and purpose of the convention. Okay, is that clear up till now? So and so on.
Not really. I'm sorry. I haven't understood from like the reservation, the slide before. I'm quite confused on how. Yeah, in general, I haven't understood really.
You're quite confused on what? For example, the Soviet Union has has not accepted the clause of the Genocide Convention relating to jurisdiction. Some other states parties object to the reservation of the Soviet Union. Therefore, they can consider that the Soviet Union, they could, of course, because we are talking about the past, they could consider that the Soviet Union was not a party to the Genocide Convention. So the convention was not in force between those states. Please do not speak in the classroom, otherwise I have to shout. Those states can be considered that the convention is not in force between those states and the Soviet Union. While other states have accepted the reservation of the Soviet Union, and so the convention will be enforced between the Soviet Union and those other states. I'm talking of a situation in which there is no superior organ, such as the International Court of Justice, which would decide, which would be able to decide on the case. Because it is obvious that a court would be able to decide that the reservation is incompatible with the object and purpose of the convention, and therefore the state in question would not be party to that convention. Or otherwise it could be considered, it could consider that the reservation is compatible and that the state in question is party to the convention. Did I answer your question?
Yes, thanks.
You're welcome. There was another question here, or was it the same, more or less the same question? Okay, your colleague says that a state could object to a reservation because, for example, it is contrary to a certain state, to the state which has issued the reservation, and not because it considers the reservation incompatible. Yes, absolutely. However, what is the advantage? I mean, to have Russia or the Soviet Union, we were talking about the Soviet Union and not about Russia, because we're talking of 1948. So to have the Soviet Union outside the convention can be an advantage, but it can also be a disadvantage. Because you are, if it is outside the convention, you cannot consider that the Soviet Union is bound by the Convention Against Genocide. So it is bound not to commit genocide, it is bound to prevent and repress any act of genocide. So it is an advantage, and it may be an advantage under certain points of view not to be a party to the same treaty with another state, but it may be a disadvantage from another point of view. But anyway, the consequences that you were mentioning is correct in the sense that if you leave to the parties liberty to accept or not to accept a reservation, or to object to a reservation, they will not necessarily accept or object on the basis of an objective evaluation of the compatibility with the object and purpose of the treaty, but maybe because just they don't like that reservation, or because they don't like the state in question. This is possible. Yes, please. In this case, if you refer to this advisory opinion, the opinion of the court was requested on a general issue, not on the specific reservation of the Soviet Union. to the Genocide Convention, so it was not requested to the. The states parties to a dispute could go before the court, but not with the Soviet Union, because the Soviet Union objected exactly to the provision which gave jurisdiction to the court. So the court could decide between two states which did not reserve on that Article 9 in relation to a reservation concerning another article of the convention. In that case, it could be called to decide dispute on the reservation to Genocide Convention. Okay, this is what the International Court of Justice decided in 1951, but things are not finished here because there was a further evolution with the Vienna Convention on the Law of Treaties of 1969. In fact, well, Article 19 of the Vienna Convention, we may say, codifies what the court had said in 1951, because according to Article 19 of the Convention, a state may, when signing, ratifying, or acceding to a treaty, formulate a reservation unless the reservation is prohibited by the treaty, unless the treaty provides that only specified reservations which do not include the reservation in question may be made. We have already said that the treaty prevails, but the problem is when the treaty does not regulate the issue. So in cases where the treaty does not regulate the issue, the reservation is incompatible with the object and purpose of the treaty. So a state may formulate a reservation unless the reservation is incompatible with the object and purpose of the treaty. This is what the court had said in 1951. And then it regulates objections to a reservation. And here, the Vienna Convention introduces a further element of flexibility with respect to the ICJ. Because according to the Vienna Convention, and this is the rule which dominates today, an objection by another contracting state to a reservation does not preclude the entry into force of the treaty as between the objecting and reserving state, unless a contrary intention is definitely expressed by the objecting state. And further, a reservation is considered to have been accepted by the state if it shall have raised no objection to the reservation within a certain time limit. I do not tell you the time limit because it does not matter. It is not a customary law provision. Customary law does never know precise time limits. So time limits you find in the Vienna Convention are only valid under the Vienna Convention and the customary. So the concept is that if within a certain time the other states parties do not object to a reservation, they are considered to have accepted the reservation. While if a state objects to a reservation, the treaty nonetheless enters into force between the two states, unless the objecting state clearly states that he or she or it does not intend to the reserving state to be a party to the. But the problem is, what are the effects of the reservation in this case? Now, what happens? What are in general the effects of the reservation? The general effect of a reservation is that a reservation established with regard to another party. So between the reserving state and the accepting state modifies for the reserving state in its relations with that other party the provisions of the treaty to which the reservation relates to the extent of the reservation, and modifies those provisions to the same extent for that other party in its relations with the reserving state. So what Article 21 Vienna Convention is stating is that the effects of the reservation are obviously mutual, reciprocal. Because take the case of the Soviet Union. If the Soviet Union is saying, I do not recognize the competence of the International Court of Justice on a dispute relating to genocide, Italy cannot bring the Soviet Union before the ICJ on a dispute relating to genocide. But even the Soviet Union cannot take, obviously, Italy before the ICJ on a dispute relating to genocide. So the effect of a reservation is that the reservation produces its effects. So it modifies the treaty as wished by the reserving state in the mutual relations between the reserving state and the accepting state. But the problem is what happens with the objecting state, which has not declared that its contrary intention to the entry into force of the treaty with the reserving state. In this case, according to paragraph 3, Article 21, when a state objecting to a reservation has not opposed the entry into force of the treaty between itself and the reserving state, the provisions to which the reservation relates do not apply as between the two states to the extent of the reservation. This is a bit of an ambiguous provision, but probably it wants to say that the reservation produces its effects. You take the case once again of Article 9 of the Genocide Convention. When a state objecting to the reservation of the Soviet Union has not opposed its entry into force of the treaty between itself and the reserving state, Article 9 of the Genocide Convention does not apply as between the two states to the extent of the. So Article 9, in fact, does not apply as between the two states, because this was the object of the reservation. The reservation of the Soviet Union is a clear example of the first type of reservations, reservations excluding the application of provision of the treaty in relation to the reserving state. It is not an interpretative declaration. Is all this clear? Yes, please. The reservation applies because the provision to which the reservation relates, Article 9 of the Genocide Convention, does not apply as between Russia, the Soviet Union, because it was the Soviet Union and the objecting state, to the extent of the reservation. So it does not apply because the extent of the reservation was to exclude Article 9. Yes, please. we can say that the reserving state is in a position of force, yes, but take into account that the objecting state has the possibility to say the treaty does not enter into force between me and the reserving state. But if it doesn't want to completely exclude the reserving state from the treaty, the reserving state, in fact, is winning. Okay? Now, the issue is not yet finished because there has been in the practice of states a subsequent evolution. In some cases, the possibility of late formulation of a reservation has been a thing, so even after ratification of a treaty. But the most interesting practice has happened in human rights treaties, in particular on the basis of a case law of the European Court of Human Rights, which is the body competent in relation to the interpretation of and control on the application of the European Convention on Human Rights, and the Human Rights Committee, which is competent in relation to the International Covenant on Civil and Political, or a UN treaty. The difference is that the European Court of Human Rights is an international court which issues binding judgments, while the Human Rights Committee is a treaty body which only issues considerations which are not binding on the states. So it is not a court. They decided, we can say substantially, that due to this case law, this jurisprudence, reservation by a state to a human rights treaty, which is considered to be incompatible with the object and purpose of the treaty, will fall, which does not prejudice the participation, the continuous participation of the state to the treaty in question. I clarify what I just said. The European Court of Human Rights, faced with a case concerning a reservation, particularly there was a reservation of Switzerland to the European Convention on Human Rights, which the court considered to be incompatible with the object and purpose of the European Convention on Human Rights. But the court said, this was the early law case, Belilos case, 1988, it said that Switzerland, so the reservation is invalid, so it is not there. It's as if it was not there. However, Switzerland is and considers itself party to the convention. So the question is a bit more complicated, because it was the court was not saying, I oblige Switzerland to be party to the convention in any case to continue to be part of the convention, but it said Switzerland continues to be a party to the convention, and in any case it continues to it considers itself a party to the convention. The Human Rights Committee followed this step, but it was more difficult for the Human Rights Committee because states tend not to accept the position of the Human Rights Committee in these cases because it's anyway its considerations are not binding. But anyway, we may say there is a tendency to consider that reservation to human rights treaties poll if they are incompatible with the object and purpose of the treaty. Nonetheless, this does not prejudice the continuous participation in the treaty of the state, of the reserving state. Now, due to this evolution in practice, as I already mentioned, the International Law Commission considered again the issue of reservations to treaties and issued in 2011, if I well remember, yes, 2011, its guide on reservation to guide to practice on reservation to treaties. Well, the guide confirms that a reservation which is incompatible with the object and purpose of the treaty is invalid, and unless the author of the invalid reservation has expressed a contrary intention, or such an intention is otherwise established, it is considered a contracting state without the benefit of the reservation. And the author of the invalid reservation may express at any time its intention not to be bound by the treaty without the benefit of the reservation. So this is a bit different with respect to the jurisprudence I was mentioning a moment ago. It takes into consideration the words I said before. Switzerland continues to consider itself bound by the convention. Therefore, what matters is the intention of the reserving state. The reserving state loses its reservation because the reservation is incompatible with the object and purpose of the treaty, so the reservation is invalid. However, the reserving state will continue to be considered bound by that convention unless it expresses its contrary intention. So the reserving state has the possibility of stating that if its reservation is not accepted because it is incompatible with the object and purpose of the treaty, it considers itself not to be bound by the treaty. Is this clear? So what matters is the intention of the reserving state. And the guide, the ILC guide, does not distinguish between human rights treaties or other treaties. What matters is the intention of the reserving state. If it has been decided that the reservation of a state is invalid because it is incompatible with the object and purpose of the treaty, the reserving state will continue to be considered the party to the treaty without the reservation, unless it expresses its intention not to be part of the treaty. Yes, please. All treaties. Any other question? in the case of Switzerland, the court said the Swiss reservation is incompatible with the object and purpose of the convention. Therefore, the Swiss reservation is invalid. Nonetheless, Switzerland continues to be and considers itself a party to the convention. Any doubt? Yes, please. No, not that of the ICJ. Certainly, the one of the Vienna Convention may be considered corresponding to customary international law. We may say that it is difficult to say whether the guide to practice of the ILC corresponds to customary international law, but we may say that there is a tendency of custom to go into this direction of a greater flexibility, which in this case means a state can be considered a party to a treaty even if it has issued an incompatible reservation, because its reservation will fall down, and however, the state will continue to be a party to the treaty, unless, of course, it shows its intention not to be. So the tendency is towards a growing flexibility. However, the question is clear that the reservation, contrary to the object, incompatible with the object and purpose of the treaty, is invalid. Obviously, in the case of the human rights treaties, there is a body which normally will be able to pronounce on the issue, while this does not happen for many other treaties. So, if a treaty has no body, superior body competent to decide whether a reservation is compatible or not with the object and purpose of the treaty, the issue will continue to be decided by the other states parties with their acceptances or objections. Any question? Any other question? Okay. Anyway, this is clearly the most difficult part of the law of treaties, and one of the most difficult parts of international law. Now, let us come to your homework. So, when I say homework, it is not binding. I'm not giving binding assignments. It is a strong invitation. So you are requested to find, each one of you, to find a treaty of your choice, to find a reservation to that treaty of your choice, clarifying whether it is a reservation of type 1 or of type 2, so excluding reservation or a conditional interpretive declaration, and to say your opinion on whether the reservation is or is not compatible with the object and purpose of the treaty. Now, I will give you some, is it clear? Is the assignment clear? I repeat, finding a treaty of your choice. Finding a reservation by a state party to the treaty of your choice. Specifying whether it is a reservation of type 1 or type 2. Specifying whether, in your opinion, it is or it is not compatible with the object and purpose of the treaty. Now, I give you some help if you want it, in the sense that you may choose, well, we have already considered international humanitarian law. If you go on the ICRC website, National Committee of the Red Cross, you find the Convention on International Humanitarian Law. Otherwise, on the UN website, you find under our work, you find human rights. Then you go onto the web pages of the Office of the High Commissioner for Human Rights. And then you find the treaties. Okay, let me see if, anyway, you may go on the okay, databases. No, let us go on the treaty bodies. Here, issues. Sorry, I didn't remember. Issues, under issues you find human rights instruments. And here you have a list of all the human rights treaties. And if you go on a treaty, for example, Convention on the Rights of Persons with Disabilities, then you will find the so you find the table of the states parties anyway, and you find in the table of states parties you find the reservations. So let me see. The treaty body database. No, it is not this one, but for example, if you take the International Covenant on Civil and Political Rights, Universal Human Rights Instruments, ratifications and reservations. You find at the end, you find also this general document on ratifications and reservations to the different treaties. Okay. And if you are more interested in disarmament, you can go on the disarmament, UN disarmament web page. So you go our work, you go on peace and security, then peace and security, you go on disarmament, Office for Disarmament Affairs. This is if you want, of course, to do all the process, because you can just click on Google and you will find even an easier path. But anyway, here under in the UNODA website, you find the resources and applications. You find the disarmament treaties, and you find the states parties and the reservations when you go on the different pages. So these are only suggestions, because you are not bound to choose a human rights treaty, a disarmament treaty, or a humanitarian law treaty. You can choose any treaty you wish. And you can send me your exercises. It is just a few words that you will have to write down. You can send them to me on the chat on Teams, and so I will have a look at them before next class on Tuesday, and I will comment on them on Tuesday. So I will not answer to your chat, but I will comment on your answers on Tuesday. Okay? Everything is clear? Any doubt? No. Very good. So now we still have some time to start with our new topic, which is the invalidity and termination of treaties. Okay, the pause has ended. Now, the invalidity of a treaty means that a treaty is considered as invalid because of the presence of a circumstance that renders it invalid, and therefore the treaty is considered as void, as non-existent, as if it had never existed. Therefore, invalidity is typically a circumstance that produces retroactive effects, because the treaty will be considered as void since its coming into force since its existence, its birth, since its adoption. It will be considered as if the treaty had never entered into force. While the circumstances producing a termination of treaties are circumstances that arise during the life of a treaty, which terminate the treaty. Termination produces effects for the future, but not for the past. So termination has no retroactive effects. Let us start with the circumstances producing invalidity of a treaty. We already considered two of these circumstances. Article 46 of the Vienna Convention on violation of internal law. You remember when the treaty has been concluded by a state in violation of the fundamental rule of its national law. And we have seen that in certain cases, this may produce the invalidity of the treaty. The other circumstance, fundamental circumstance we have already considered is the violation of jus cogens. We have seen that a treaty conflicting with a rule of jus cogens is invalid, and so it is if it has never come into force. But the Vienna Convention considers some other possibilities. So according to Article 48 of the Vienna Convention, one of these causes, one of these circumstances is error. A state may invoke an error in a treaty as invalidating its consent to be bound by the treaty. If the error relates to a fact or situation which was assumed by that state to exist at the time when the treaty was concluded and formed an essential basis of its consent to be bound by the treaty. However, paragraph 1 shall not apply if the state in question contributed by its own conduct to the error, or if the circumstances were such as to put that state on notice of a possible error. The error must be relating to a fact or situation. I make an example. You have a treaty defining the boundary between two. The error is that one of the two states is convinced that in a certain remote area of the country where the frontier is running, there is a tropical forest, while that area is in fact a desert. This is an error relating to a factual circumstance, to a fact, to a situation. In this case, the state in question may adduce the error in case as a factor in validating its consent to be bound by the treaty. If that fact was an essential basis of its consent to be bound by the treaty. Had the state known that the area was a desert, it would not have claimed the whole area of that desert, but it would have claimed another distribution of another remote area where there is tropical forest, be able to benefit from the resources of the tropical forest. I mean, there can be different reasons why a fact is a basis of the consent of a state to be bound by a treaty. The error considered by Article 48 is not relating to the law, cannot be related to the law. A general principle of law, which is also accepted in international law, is the error of law is not an excuse. Ignorantia legis non excusat. Ignorance of the law is not an excuse. So if you don't know the law, it is your problem. Even a state cannot invoke an ignorance of the law, of international law. And an error is not even relating to the wording of the text. If there is a mistake in the spelling of a word in the text of the treaty, in the drafting, in the material drafting of the treaty, this can be corrected through a special procedure contained in the Vienna Convention. But it may not be invoked as a mistake in validating the consent of a state to be bound by the treaty. A further consequence, a further circumstance considered by the treaty by the Vienna Convention is fraud, Article 49. If a state has been induced to conclude a treaty by the fraudulent conduct of another negotiating state, the state may invoke the fraud as invalidating its consent to be bound by the treaty. This is a very interesting circumstance, but I cannot quote an example of this to you. It's very difficult to have a case in which a representative of a state tries to present a situation to the representative of another state which is completely false in order to induce that party to conclude a treaty. So it is very theoretical, this cause of invalidity. The same may be said for the corruption of a representative of a state. So the case in which Article 50 of the Convention, the case in which the representative of a state would pay a sum of money to the representative of another state to induce him to conclude a treaty. I cannot quote any complete example of this ever happened. Another case is the coercion of a representative of a state, Article 51. Also, this is not so easy to take place in practice. The expression of the state's consent to be bound by a treaty which has been produced by the coercion of its representative through acts or threats directed against him shall be without any legal effect. there is one historical case when the the other case, I will mention it in a moment, the other case is the coercion of a state. So in the case considered by Article 51, you're using violence against the representative of the other state, or a threat of violence against his person or her person in order to induce him or her to sign the treaty. To sign the treaty. In Article 52, it is the coercion against the state, the other state, not the representative of the other state, by the threat or use of force. And it states that the treaty is void if its conclusion has been procured by the threat or use of force in violation of the principles of international law embodied in the Charter of the United Nations. This obviously is already more easily a situation which more easily could take place in practice. A historical case involving both Article 51 and Article 52 is considered to be the case where Hitler and the German leaders threatened the use of force against Czechoslovakia, against the state of Czechoslovakia, but apparently they even physically threatened the head of the government, of the Czech government, and the Czech leaders who were present in the room in order to induce them to cede to the occupation of Czechoslovakia by Germany. Apparently that was really a threat of also of physical violence against the leaders, and not only against the state, to induce the Czech representative to cede to the Nazi wishes in that case. Well, a treaty concluded in such a case would be considered invalid and therefore non-existent. Now, the question in relation to Article 52, the question may be whether a treaty of peace, what happens with a treaty of peace? We may say that a treaty of peace is never concluded on the basis of the free will of the vanquished state. A treaty of peace is always imposed by the victor state on the vanquished state. And therefore, the question may be, are treaties of peace invalid because they conflict with Article 52, because they according to Article 52 of the Vienna Convention on the Law of Treaties. Now, we have seen the formulation of Article 52, which says that a treaty is void if its conclusion has been procured by the threat or use of force in violation of the principles of international law embodied in the Charter of the United Nations. Therefore, we may consider that if the state which has won the war in violation of the prohibition to use force contained in the UN Charter, the peace treaty will be invalid. While if the state which has won the war a war which was started by the other state in violation of the United Nations Charter, in that case, the peace treaty is perfectly valid. So even if it is the result of coercion, that coercion cannot be considered as in violation of the Charter of the United Nations. So the state which has won the war acting in self-defense will be able to impose its will on the vanquished state and to conclude a valid peace treaty in this way. Well, the question is difficult because anyway, even the state which has acted in self-defense, it could not threaten the other state, I will aggress you if you don't sign this treaty. So the question is complex, but anyway, peace treaties have always been considered valid up till today. It is clear that they are concluded to a certain extent as a result of coercion. Any question? So we have seen that some of the invalidity causes of for treaties are in fact more theoretical than corresponding to real practice. But certainly there can be some limited cases of error. The important cases are certainly the conflict with the Uskogans and the violation of internal law under Article 46. And there are some real issues under Article 52 in relation to coercion in particular. Now, coercion is intended as the use of military force or the threat of military force. Because the so-called, the developing countries pushed for a wide concept of coercion, which would include also economic coercion. Can a state use economic coercion on another state to conclude a treaty? I will withdraw my financial help to you if you don't sign this treaty. Can a state threaten, I will withdraw all my money if you don't accept the trade agreement which is favorable to me, if you don't accept this? This was not accepted by the Western states in particular. The only result of this debate was a declaration issued by the Vienna Conference on the Law of Treaties, which is included in the final act of the Vienna Conference on the Law of Treaties on the prohibition of military, political, or economic coercion in the conclusion of treaties, according to which the use of pressure in any form, whether military, political, or economic, by any state in order to coerce another state to perform any act relating to the conclusion of the treaty is solemnly condemned. However, the clear consequence of this declaration is that the threat of political or economic, the use of pressure in political or economic form, the threat of political or economic consequences does not render a treaty invalid. Many of the existing treaties are being concluded, have been concluded under political or economic pressure on the part of the strong states over the weaker states. This is the reality of international relations. Those treaties are considered perfectly valid. Only military coercion is considered a cause rendering a treaty invalid under international law. Any question? Any comment? Okay, so we finish here. We will do the termination causes next time. Have a nice weekend.